Good day, members of the media who are in attendance and may be listening to this media statement, and also good day to members of the public who will be listening to the rebroadcast of this media statement. The Judicial Committee of the Privy Council, which is the final court of appeal for Trinidad and Tobago, gave a judgment today in which it upheld the unanimous decision of the Court of Appeal of Trinidad and Tobago and the decision given by the High Court in favor of Junior Sammy Contractors Ltd, hereinafter referred to as a contractor, against the Estate Management and Business Development Company Limited, hereinafter referred to as EMBD. This is an important judgment for many reasons. One of the reasons is that it totally vindicates the character and reputation of Junior Sammy and its managing director, Mr. Junior Sammy. It vindicates the reputation of Junior Sammy Contractors Ltd and its managing director, Mr. Junior Sammy. This appeal concerned a claim which was filed by the contractor against EMBD for sums of monies owed to it in respect of construction works done for EMBD pursuant to this contract. The engineer of this standard form contract, known as the FIDIC Red Book edition, was the agent of EMBD, and in accordance with the terms of that contract, certified the sums claimed by the contractor for works done under the contract. The engineer certified the sums claimed as fair, and the sums represented an accurate assessment of the value of the works done by the contractor. EMBD paid part of the sums claimed by the contractor and refused to pay the balance of the sums claimed by the contractor, which sums were certified by the engineer of the contract as being fair and due to be paid. The contractor had to file a claim before the High Court in which the contractor claimed the sums which EMBD refused to pay. The contractor had to take a loan from Answer Merchant Bank in respect of which it had to pay interest on that loan for that loan to be used to complete the construction works undertaken by the contract. In addition to the engineer of the contract certifying the value of the works, representatives of EMBD, in the presence of the engineer at the site of the construction works, had a joint inspection of the completed contractual works. The representatives of EMBD, after that joint inspection by representatives of both the contractor and EMBD, agreed in the presence of the engineer that the contractor had satisfactorily completed the works of the contract. It was not disputed in the case before the courts that the contractor had satisfactorily completed the works of the contract. Notwithstanding that the engineer, which was the agent of EMBD, certified that the value of the works were fair and represented the true value of the works done by the contractor, and EMBD agreed through its representatives that the works were satisfactorily completed in accordance with the contract, EMBD refused to pay the contractor for the completed works of the contract. The contractor commenced a claim in the High Court against EMBD to recover the sums of money outstanding by EMBD in respect of the works done in relation to the contract. EMBD, in answer to that claim, put in a defense to the claim. The contractor applied for summary judgment, putting forward to the court that the defense which EMBD put into the claim did not in effect disclose a real defense to the claim. It was based on mere suspicions. Both the High Court and the Court of Appeal held that EMBD did not have a defense to the claim. EMBD then appealed to the Privy Council, and the Privy Council today endorsed the judgments of both the High Court and the Court of Appeal in finding that EMBD did not have a defense to the claim, and also held that the defense filed by EMBD did not have any merits. This decision of the High Court, the Court of Appeal, and the Judicial Committee of the Privy Council has totally vindicated the reputation of both Mr. Junior Sammy and his company, Junior Sammy Contractors Ltd, in a claim in which EMBD alleged fraud against them. The Privy Council held that the allegations made by EMBD of fraud in its defense had no substance. The three courts comprising 9 judges all held that there were no merits in the defense of EMBD to the claim. The Judicial Committee of the Privy Council, affirming the decisions of the High Court and the Court of Appeal, made it crystal clear that there was no evidence produced by EMBD to show that there was any fraud committed by the contractor or the engineer. On the contrary, the Judicial Committee of the Privy Council held that the pleading of fraud in defense of EMBD demonstrated that EMB did not have any defense to support fraud against the contractor. This judgment is also of importance to the construction sector in Trinidad and Tobago. The government and state-owned companies which employ contractors to do construction works and other infrastructural works use standard form contracts such as the FIDIC contracts, which was used for this particular contract. It is common in the Commonwealth, including the Eastern Caribbean, for governments and state-owned companies to use the FIDIC Standard-Form Contract to enter into contracts with contractors for the performance of construction and other related works. This judgment therefore creates a legal precedent in Trinidad and Tobago and in the Commonwealth for the interpretation by the Privy Council of Clause 14 of the FIDIC Red Book contract, which mandates that the employer of the contractor must pay to the contractor sums certified in the interim payment certificates, which are certified by the engineer and issued to the contractor. The procedure stated in the FIDIC contract shows that the engineer of the contract investigate the application made by a contractor for an IPC, an interim payment certificate. I'll refer that as the IPC to be certified. The engineer conducts measurements, investigates the claim, makes a fair assessment of the claim. The engineer then certifies the value of the works in the IPC and issues the IPC to the contractor. The contractor then sends an invoice to the employer based on the sum certified in the IPC for payment to the contractor. Now, one of the common features of FIDIC contracts, which the government uses and which the private sector sometimes uses and which are used throughout the Commonwealth, is that the employer of the contract appoints an agent, a suitably qualified agent, who that engineer is the agent of the contract. Is the agent of the employer. That engineer of the contract measures the works, certifies the value of the works, and the contractor, and the employer honors that certificate made by its agent. That is a common feature of the FIDIC contract. And when that IPC is certified by the engineer under the terms of the contract, the employer is supposed to pay. If the employer wants to challenge the certification of the engineer, there are provisions within the contract for that to be challenged, either by the employer or by the contractor. And the law has developed that where you have such a contract, the only thing or the only defense which an employer has in not paying a claim certified by the engineer is if the employer can show that there was fraud in the issue of the interim payment certificate. So that is what the EMBD tried to do in this case. But as you would see, it was shown that it did not have any fraud defense. There were merely suspicions pleaded, and the courts frowned on that because fraud is a serious allegation and it must not be used by a defendant unless there is evidence to support it. So the contract itself, I think I should try to give you an idea of the contract which was entered into. This written contract was entered into between EMBD and the contractor, and the contract was to carry out residential infrastructural works at the Caroni Savannah residential development for the purpose of housing to be constructed. So this contract was only for the purpose of building roads and doing the infrastructural works. EMBD awarded a contract to the contractor in February of 2015. There was a public tender, and the contractor won that tender. The FIDIC contract provided, as I stated, that EMBD had to employ a competent engineer, one suitably qualified to be the agent of the employer and to perform the functions of the engineer. The engineer of this contract was a firm called VCAB Engineering Consultants Ltd. And that is a firm which carried on practice at the time as civil and structural engineers, architects, quantity surveyors, project managers, chemical and mechanical engineers. The provisions of that FIDIC contract stated that in respect of each tranche of works of the contract, which was done by the contractor was entitled to apply to the engineer of the contract for an interim payment certificate, IPC, for the engineer to certify the value of the works performed by the contractor. The contract required the contractor to submit a statement with supporting documents to the engineer of the contract for the contractor to justify the value of the works claimed to be paid for that said tranche of work. When the engineer gets that application in accordance with the contract, the engineer investigates the claim and the supporting documents. The engineer conducts measurements of the works claimed to be done, and then make a fair assessment of the value of the works. If the engineer then certifies the value of the works assessed, then either party can challenge that assessment. And if within the provisions of the contract, they can't go to court to challenge that. There are machinery within the provisions of the contract to challenge that. And as long as the engineer certifies that and it is found that no appeal has been succeeded within the provisions of the contract, certifies the value of the works of the contract, then that certificate is good as gold. The contractor is entitled to receive his monies within a specified period of time specified in the contract. What EMBD did in this case is that the first 6 interim payment certificates, EMBD paid those 6 payments. In respect of the 7th interim payment certificate, it paid part of the sums due and had a balance, and then it did not pay interim payment certificates 8 to 13. There were 13 interim payment certificates in all. And as I said, there were timeframes provided in the contract for the payments to be made. Now, notwithstanding, EMB did not make these payments, and you would see the contractor made several efforts to get these payments. The contractor took steps to complete the works of the contract. But since the company did not have money because it was not getting paid, the contractor decided to raise a loan with finances, with some of the financial institutions in Trinidad and Tobago, and made applications for that purpose. The contractor applied to First Citizens Bank, and First Citizens Bank wanted evidence from EMBD showing that a debt was owed. The contractor was able to get a letter from the Chief Executive Officer of EMBD, dated the 9th of October 2015, which letter formed part of the evidence before the court and the Privy Council. That letter was addressed to First Citizens Bank, in which EMBD confirmed through the Chief Executive Officer the financial status of the project and stated the outstanding sums which had to be paid by EMBD to the contractor under the contract. The contractor, however, had to go to another finance institution, Answer Merchant Bank. But in order to get that financing, the contractor had to assign the benefit of the debt, which EMBD owed it to Answer Merchant Bank as security for the financing. In that assignment agreement, however, it was made clear by the contractor that the contractor would have the right to file any claim against EMBD in order to recover the debt from EMBD. The contractor wrote several letters to EMBD in which it made requests for payment of the sums certified in the IPCs which were outstanding. So we have a situation where the contractor completed the works and was still trying to collect the debt owed to him. EMBD responded in which it stated that it had contracted a third-party expert to conduct audits of some of its projects, and it would communicate with the contractor when the audit was completed. EMBD 6 months later, in May 2017, stated to the contractor that the line ministry of EMBD received a preliminary report in respect of the audit it conducted of the works of that contract and promised to get back to the contractor in respect of the payment sought by the contractor. Notwithstanding EMBD's assurance in the letter of the 9th of May 2017 that as soon as a final determination was made in respect of the payment, EMBD would communicate with the contractor. EMBD did not provide any further update to the contractor. It also did not provide the contractor with a copy of any preliminary audit report, and it also did not consult the contractor in respect of any investigations which it was conducting to audit that contract. The contractor, notwithstanding all of that, made further efforts in letters dated August 2017 and October 2018 to get a response from EMBD in respect of its claim. EMBD did not respond. The contractor, therefore, had no alternative to file a claim against EMBD in the High Court to get payment of the debt owed by EMBD in respect of the IPCs. That claim was filed on the 20th of December 2018. After the claim was filed on the 20th of December 2018, EMBD adopted the position that the contractor ought to disclose to EMBD documents. Those documents which EMBD sought to be disclosed were documents which the contractor would have supplied to EMBD through its agent, and which the contractor did not have any obligation under the contract to provide to EMBD. EMBD therefore had access to those documents which were in the possession of its engineer, and in any event, EMBD would have had to have sight of those documents, because after the IPCs, interim payment certificates, were certified by the engineer, the contractor then had to prepare an invoice with the details of the interim payment certificates to send to EMBD in order to get payment. So that invoice was sent in respect of the 13 IPCs to EMBD. So the contractor took the position to the court that EMBD already has these documents in its possession, and EMBD was just trying to delay the whole process of our client getting a judgment. EMBD filed its defense, and in its defense, EMBD stated that it needed disclosure of these documents, and it needs these documents in order to determine whether there exists its suspicions of fraud in the certification of the IPCs. And if there was such fraud, then the sums which were certified would be less than what was certified by the engineer. EMBD contended that unless it got specific disclosure of these documents, it was hampered in pleading its defense. Upon that defense being filed by EMBD and having regard to the contents of that defense, the contractor's lawyers took the position that the contractor did not have to wait for a whole trial to happen. The contractor was entitled to file in the court an application for summary judgment based on the defense and the claim which was filed by the contractor and the defense filed by EMBD. So the contractor filed an application for summary judgment based on the fact that the defense of EMBD did not disclose a defense. The contractor contended before the court that the fact that the defendant had suspicions of fraud is not sufficient in law to plead a defense. The law required that when a fraud has to be pleaded, it must be pleaded with full particulars in order to give the other side the opportunity to answer the allegations of fraud. Consequently, EMBD did not plead a defense of fraud, and therefore the defense had pleaded for a reduction in the price of the works done, which is called abatement, has no merits. In respect of the defense that the contractor, well, I should tell you this. EMBD also raised the defense that since there was an assignment of the debt to Answer Merchant Bank, the contractor did not have any standing to file the action. And in defense, we put forward that although there was this assignment of the debt to Answer Merchant Bank, the assignment agreement expressly stated that all claims in respect of the debt had to be filed by the contractor. So the attorneys at law on behalf of the contractor put forward that the defense did not worth anything, it did not disclose a defense, and that the contractor did not have to wait for a trial of the claim. And so the question which arose for the court, the High Court, was whether the contractor was entitled to get summary judgment. That application was heard in the High Court before Justice Miradina Amara. EMBD retained an English QC to attend the hearing in Port of Spain to contest that application for a summary judgment. The judge, after hearing submissions of both sides, granted summary judgment in favor of the contractor. Together with interest which accrued and together with costs and interest to further accrue until the judgment was paid. EMBD appealed the judgment to the Court of Appeal. The Court of Appeal heard the appeal. The same English Queen's Counsel appeared on behalf of EMBD and argued the appeal. The Court of Appeal reserved judgment, and the Court of Appeal then delivered a written judgment and gave a unanimous judgment dismissing the appeal. The court comprised the Honorable Chief Justice, Ivor Archie, and Justices of Appeal Charmaine Pemberton and Ronnie Budusing. EMB decided to appeal to the Judicial Committee of the Privy Council and the same English, at that time he became King's Counsel, appeared in the Privy Council to argue this appeal. The Privy Council dismissed the appeal, as you see from the judgment today, and affirmed the orders made in the High Court and the Court of Appeal. The Privy Council, in its written judgment, decided inter alia as follows. The FIDIC contract, clause 14, required EMBD to pay the sum certified by the engineer in the IPCs. EMBD's defense that it had reasons to believe fraud or suspicion of fraud in the issue of the IPCs by the engineer had no merit and did not constitute a defense in law to the claim. At paragraph 95 regarding the contention of EMBD, that it had a real reason to believe that the works were over-certified or incorrectly certified by the engineer, those reasons given by EMBD were not supported by any expert witness. At paragraph 108, the Privy Council held that none of the employer's reasons for suspicion individually or collectively have sufficient substance to establish the potential defenses of abatement and of fraud. They amount to mere speculation, and EMBD failed to demonstrate that the potential defenses of abatement and or fraud are no more than fanciful or speculative. At paragraph 109, the Privy Council held that the application for specific disclosure of documents by EMBD was a fishing expedition, and it amounted to no more than hope that something might turn up. The importance of this judgment. This judgment is important not only because it vindicates the reputation of my client. It is important because government and state-owned companies use this kind of contract to, in effect, get contractors to do construction works and infrastructure works. The terms of this judgment should make government and state-owned companies consider taking measures to put administrative measures and infrastructure in place to ensure that claims made by contractors, when properly assessed and show that there is no defense to the claim, the government and the state-owned companies should not waste financial resources spending money on legal fees and other costs to defend those claims. This is important because it would save taxpayers' monies, which would be saved by not having to pay legal costs to defend the claim, the interest accumulated on some claim, and to pay legal costs for those who file the claim. I'm sure that you would agree with me that those expenses can be saved and used for the benefit of the people of Trinidad and Tobago. The government and state-owned companies ought also to take steps to ensure that there is no delay in payment of cases where interest accrues on such debts and in respect of claims which can succeed and in which there is no defense to put forward by the state. The effect of this judgment is therefore extremely important to the public interest because it creates a situation for government and state-owned companies to put the requisite measures in place and not to put forward defenses to claims or be misled in putting defenses which have no merits. I would also urge persons in the construction sector, including contractors, the government and state-owned companies, to get their personnel to read the contents of this judgment, as it would help them to know the rights of the contractors and the rights of the employers of the contractors. I would like to mention another matter which, in my view, impinges on something like this. There was another matter about a year ago in which I was involved in, and which the contractor did works for the government of Trinidad and Tobago. But the contractor was not paid for those works, and the contractor had to resort to litigation. The contractor spent substantial sums of monies doing these contractual works for the government, but did not get paid for most of the works which were done by the contractor. The government in that case took the position that the claim of the contractor was defeated because the contract was entered into, because the contract which was entered into between the government and the contractor was void for want of authority of the public official, or it was ultra vires the powers of the public officials to enter into the contract. The matter reached the Privy Council, and I argued before the Privy Council that notwithstanding that the contract was ultra vires or void for want of authority of the public officials, the Court of Appeal was correct in holding that the state was liable on the ground for the contractor to get relief. Otherwise, the government would have been unjustly enriched by the contractual works of the claimant. The Privy Council agreed and endorsed the judgment of the Court of Appeal and gave judgment for the contractor based on the claim of unjust enrichment. This was the case of the Attorney General of Trinidad and Tobago versus Trinsalvage Enterprises Limited. This is an important matter because contractors ought to know their rights, and government and state-owned companies ought not to take the position of being unjustly enriched by the works of contractors. That is certainly not in the public interest. Because of all these matters, my client has asked me to make an announcement to the public that his company, Junior Sammy Contractors Ltd, would either in the month of December this year or in the month of January next year sponsor a conference on standard form contracts, including the FIDIC contracts, to which contractors, persons in the construction industry, government officials, and officials of the state-owned companies would be invited to attend. He would arrange for the lawyers who represent him in the Privy Council in this matter, Mr. David Thomas of Keating Chambers in London, together with Mr. Robert Strang of Tree Hair Court in London, and Mr. Richard Langley of the London firm of BDP Pittmans, and the members of the legal team in Trinidad who assisted me in the High Court and the Court of Appeal to make presentations at this conference. The purpose of that conference would be for contractors and employers to know their rights under the contracts under which they operate, in order for contractors to enforce their rights under the contracts, and also for government and state-owned companies to understand their obligations under the contract. Thank you very much. I would arrange for a copy of this statement to be sent to the media, and may I thank members of the media for attending the media conference. Thank you.